Welcome, everybody, to what's already the 7th seminar in the International PhD in Progress seminar series organised by the Global South Network. And obviously, as always, I would like to thank Dr. Noman Rayat, who has organised and coordinated the series and also is the convener of the Global South Network. My name is Rhona Smith and I'm Professor of International Human Rights at Newcastle University Law School in the UK. My work tends to focus on various aspects of human rights, and I've also served in the UN as a UN Special Rapporteur with a country mandate. So I've worked in human rights in practice and also in theory. And it's my great privilege to be chairing the session today. Every week, this is definitely one of the highlights because I learned something new and there's so many amazing and really inspiring researchers. So it's always wonderful and it's a great privilege, therefore, to be chairing it today. The session is being recorded, so if anyone has got any objection, please can you post it in the chat because I think I can override Noma's recording and stop. So let me know if anybody has got any objection, I can get it stopped. Or rather, I can stop it afterwards so as it doesn't go anywhere, so both ways. Right, okay, in that case, I don't think there's anybody else that's indicated a problem with it. Okay, do let us know because it's not a problem at all if you want the recording removed and not to be shared, that's fine. Okay, so on to today's very interesting session that we have. I am joined by Dr. Tom Frost, who is the discussant for the session. He's senior lecturer at Kent Law School and he's previously worked at Leicester, Sussex and Newcastle. If that's Newcastle, UK, that was before my time there, but you're very welcome. And he also has worked in the UK government as a civil servant. So his research interests focus on the history of the British Empire, including the governance of the British colonies and British involvement in the slave trade, decolonial approaches to public law, and the figure of the slave in Western European philosophy and political thought. Our peer commentator you will recognise is Roua Al Taweel, who's still on her fieldwork after having bravely managed to present from an airport and while travelling, I think. So she's now joining us this time as a peer commentator. And she's a PhD student at the School of Law in Ulster in Northern Ireland, and her PhD focuses on narratives of transformative gender justice, the interplay of Syrian nationality laws and forced displacement. And she's currently in Germany on fieldwork, so it's very kind of her to agree to serve as our peer commentator today. And that brings us on to the most important person in this afternoon's session, last but not least, our guest speaker and presenter. And I apologise if I get her name wrong, is Yelyzaveta Monastyrova, who's a PhD candidate at the Law School of the Open University, so presumably that's in the UK. And her thesis focuses on the inclusion of exploitation of citizens into the anti-trafficking regimes in Spain, Ukraine and the UK, as well as exploring elements of the relationship between victimhood and citizenship. Yelyzaveta also holds an Erasmus Mundus joint master degree programme in Southern European Studies, which was from a cross of the University of Glasgow, the Autonomous University of Madrid and Luis Guido Carli. And she also has a BA in International Relations from the Oles Honchar Dnipro University, National University in Ukraine. So Yelyzaveta, you've been kind enough to share the slides to check the technical things work. So we're ready to go and you've got about 30 minutes for your presentation, which will be followed by about 5 minutes of comments and questions from the discussant, Tom, and our peer commentator as well. and then we will open the floor to general questions and answers. So Yelyzaveta, thank you very much indeed. The floor is now yours.
Thank you very much, Rhona, for this kind presentation, and thank you and Dr. Naumann for having me here. It's a pleasure and an honor to present and to have this opportunity to share my work, and I hope that you can see my slides. So I'll try to be within the time and to share about my ongoing dissertation research, as well as to try to explain how it may fit within the broad context of the Global South Network, and why I think we can speak about human trafficking as something that also has to do with probably colonial and decolonial approaches to international law and international politics. So I'm the third-year PhD student at the Open University. It is based in Milton Keynes, so not far from London. But my research spans across 3 countries and adopts a broader international and European perspective on human trafficking. So within the presentation, I'll try to explain why I think we should focus on human trafficking and anti-human trafficking, so the actions to counter human trafficking, why it is important and what it is about, who can be trafficked, so how victims of human trafficking are constructed within the regimes of counteraction to trafficking. Then I'll go on to my case studies, and I'll provide the rationales for focusing on these 3 countries, which are not apparently comparable in all respects, and then bring you to the conclusion that I have at this point. So to start with, well, human trafficking is a word that obviously brings many sensational associations, and this is the way that the human trafficking regime and anti-trafficking regimes have been built in the international law and also in international and national policies of counteracting what is perceived as one of the most serious global transnational crimes. And when we think of human trafficking, we probably usually think of someone who is brought somewhere else, trafficked for exploitation. Usually it will be exploitation in prostitution, at least within the traditional images of what human trafficking is. And we will think of the suffering of the victims, of the evil perpetrators, and sometimes also about the clients. And the illustration that you have here is an anti-trafficking ad by the Spanish National Police that emphasizes that, yes, a person can become a victim of trafficking by chance, but we would not have trafficking without people who are ready to consume services provided by human trafficking victims. So the responsibility is partially attributed to the society. So this is a very, say, simplified overview of what human trafficking is purported to be. And since my contention is that human trafficking does not exist as such, but rather is a way we look at social practices and the way that we construct some of these practices, I guess we can talk about it as human trafficking, keeping in mind that human trafficking as such cannot be easily defined, because many different things can be understood as trafficking. So human trafficking is a research subject that probably will be considered as worthwhile and relevant by most people who look at it, because it unites so many issues. So it unites exploitation of the people who are trafficked, criminal law insofar as prosecution of the traffickers and exploiters is concerned. It involves the issues of unfreedom, and that's where we can bring in moral or political philosophy and think about what it means to be trafficked within the contemporary international system. And it also touches upon human rights of trafficking victims, which are violated in the process of trafficking and subsequent exploitation, and on the inequalities that are often cited as the root causes of human trafficking. And then, as opposed to the practices of trafficking and exploitation, we have the anti-trafficking regime, which tries to fight human trafficking, but is actually underpinned by the no less relevant issues, at least from the state perspective, of immigration control, because trafficking is usually associated with cross-border movement, and also the shrinking labor rights protection in most national states across the globe, which enable the practices of trafficking and exploitation. So when trying to locate anti-trafficking within the international law picture, I made this scheme 2 years ago and think, well, it looks confusing, but I believe it's helpful to see that when approaching trafficking, one can start from anywhere and gradually come to see the complexity of trying to regulate trafficking, because we can start with international criminal law and the UN Convention on Transnational Organized Crime and the Palermo Protocols to it adopted in 2000, which are the pillar of international anti-trafficking regime. But then we can also go to international human rights law, and from there come to the issues of migration or labor rights or refugee protection and the international humanitarian law. Then we also have the national legal systems into which all the international anti-trafficking norms have to be transposed in order to be effective, because human trafficking is countered via the cooperation between the states and criminal justice systems within the states. So human trafficking can encompass virtually any area of international law and obviously the national legal systems as well. So my research, it borders upon this international public law and different areas of international law and exploring national systems within which I analyze anti-trafficking action. So coming to the human trafficking concept, which has no, say, universal definition or consensus among practitioners or scholars, but which nevertheless has the more or less universal definitions within the international law, which are still contested, but which are the best thing we have. Human trafficking amounts recruitment, transportation, transfer, harboring, or receipt of persons by the means of the threat or use of force or other forms of coercion, abduction, fraud, deception, abuse of power or of position of vulnerability of a trafficking victim, and which is perpetrated for the purpose of exploitation. This exploitation can include exploitation of prostitution or other sexual exploitation, forced labor or services, slavery practices similar to slavery, servitude, removal of organs. So this is quite a restrictive definition, which was provided in 2000. This is already the 2005 definition, of the Council of Europe Convention on Action Against Trafficking in Human Beings. The 2000 definition of the UN Convention was more restricted in terms of kind of exploitation that can be counted as trafficking, but this list has never been meant to be exclusive. So new types of exploitation may be added to the exploitative purposes. So speaking in the briefest way, trafficking is bringing someone into exploitation without their consent, because the consent to a victim to exploitation is irrelevant where the means listed in the definition have been used. So if someone has been coerced or deceived, or their vulnerability was abused in order to gain their consent for trafficking and exploitation, it means that this consent should not be considered a valid consent. So this definition seems quite rational and quite neutral, but then it is in fact underpinned by many preceding discourses on what is trafficking and what is slavery. And I believe that these two discourses have been integrated in the contemporary anti-human trafficking policies and practices throughout the world. So when speaking about white slave trade, I mean the human trafficking discourse that appeared in the late 19th century, and that was related to the growing concerns among European public and the US public policy actors about prostitution of young girls, usually white girls, and the prostitution that was presumably controlled by traffickers, who we usually think to be foreign men. So in the UK context, which is where the human trafficking discourse appeared, for the first time in its most visible way, such human traffickers could be Jewish men, because it was at that time there was a high level of immigration from Eastern European areas, and due to discrimination that Jewish community suffered there. So with that immigration, the anti-immigration panic appeared, and the idea of a wild trafficker as a foreigner who is a danger to the local girls or even their own immigrant girls appeared. So this discourse was from the beginning quite racial and constructed an image of a local innocent white victim versus a foreign perpetrator. It was also imperialist because the concerns on human trafficking victims in Europe and in the US ignored the practices of unfree labor and, in some cases, outright slavery, which were going on in colonies of all those countries that participated in early anti-trafficking action. It was also gendered because only young women could be seen as victims of that kind of trafficking, and it was moralizing because it tried to control the way that women moved the countries and what they were doing. Then there is slavery, because the contemporary anti-trafficking discourse draws very heavily on slavery connotations and the history of the abolition of slavery. And what this discourse brings is the commodification of people who are victims of human trafficking if they are seen as slaves. In the UK, it's particularly relevant because here the broad framework within which trafficking is approached is that of modern slavery. Then there is also an idea that this slavery is imported to societies where trafficking is fought against, that those people are trafficked. Accordingly, there is no responsibility on the whole society for what is happening. And slavery that they bring with them is also imported from the societies where it can be indigenous. Well, that is not kind of what the discourse implies. And those societies with so-called indigenous slavery will be probably located in the global south. Or otherwise, the countries where trafficking victims come from can be conceptualized as those which are less developed. And then also it paints forced labor of trafficking victims as non-capitalist, because we can look at slavery from a certain standpoint as a pre-capitalist institution, which I do not agree with that idea, but it is quite common in the way that trafficking is painted in modern slavery in public policies. And accordingly, if it is non-capitalist, it is outside the free labor regulations and outside our economy. So we only need to catch traffickers and rescue the victims. We do not need to look at the causes behind this exploitation and what enables this exploitation to thrive in our societies. Then why do we even need to think about human trafficking in a liberal capitalist society as the UK is? Can be explained on the terms of this liberal capitalist society and from the standpoint of political theory, because human trafficking is seen, first of all, as an offense against personal autonomy, because someone is bought and brought into unfreedom. And this goes against one of the pillars of a liberal society. It is also a crime against the freedom of market exchange of labor force, and which is probably even more important from this perspective. And accordingly, the anti-trafficking regimes become the guardian of society members' capacity to be responsible participants of this society and self-reliable participants who do not let themselves to be trafficked and dragged into exploitation. And by the same token, it legitimizes exploitation that is consented to. But even though victims' consent is irrelevant, something must happen for it to become irrelevant. So if there is no coercion or abuse, then there will be no trafficking. Accordingly, this exploitation should not be fought as hard as trafficking should be. And this also constructs the human trafficking victim as a person who needs protection by the state who can rescue them, the person who is not self-sufficient because they have fallen out of the logic of a liberal capitalist society in which everyone is a master of their own labor. And the person who cannot claim belonging because they have been trafficked here, they are not from here. Accordingly, they can be protected, but they can hardly claim any rights. And that brings us to the relationship between anti-trafficking and human rights, which on the face value is very useful, this lens of human rights, and it has been often cited as preferable to criminalization as an approach to fighting trafficking, because we can look at trafficking as infringing many, many rights: the right to liberty, the right to life in some cases, the right to work, the right to not be subject to slavery or forced labor, torture, inhuman or degrading treatment, and also the right to justice. But in the international law, there is no right to not be exploited, which is important for the way that exploitation is looked at within anti-trafficking provisions. It's usually not looked at. There is no definition of exploitation. And also, since human rights can be seen as something enabling, so the instrument enabling the neoliberal order economically and politically, something that makes each of us the holder of those rights individually and places the responsibility on ourselves to cater for our own well-being and to be active as citizens in order to be granted those rights and to enjoy them. So all of this means that human rights as a perspective on trafficking are also limited, because they cannot transcend the order which makes trafficking and exploitation possible. And instead of trying to transcend it or to reject it or overcome it, human rights actually help to mitigate the worst phenomena of exploitation without fighting the reasons and the causes for exploitation that happens on the everyday basis. And it reinforces sustainability and resilience as something that should help those individuals who inevitably will be exploited and who should learn how to live with this inevitable exploitation rather than try to get out of this system altogether. So having said all that, human trafficking is also seen as mainly a migration problem, as cross-border mobility is something which is not an element of the human trafficking offense, but which has been there almost by default. It is seen as a crime that happens at the border. And I call it a political element of the definition because even though it is not in the definition, the first universal concept of human trafficking was adopted within the Convention on Transnational Organized Crime. So it was only applied to transnational trafficking. And in some countries, the national legislation still stipulates that for trafficking to take place, there must be movement and in some cases, cross-border movement. And it also determines the relationship between victims of trafficking and the state in which they are exploited, because this non-belonging and the sense that they are all foreign citizens who need our protection but are probably irregularly here. It is what has shaped the anti-trafficking policies and the policies of identification and assistance to victims, because non-criminalization is one of the important principles of anti-trafficking responses, and it is based on the idea that human trafficking victims will be irregular migrants. And therefore, they require humanitarian assistance, they require compassion, but they cannot reclaim any rights because they don't have them in a country which is not theirs. So since my research looks at domestic human trafficking, I encounter a lot of contradictions because I have been trying to understand why do the states now apply all this anti-trafficking framework to people who are exploited within their own countries? Because within the contemporary international anti-trafficking law and national legislations, human trafficking does not require crossing any borders. And in some countries, it does not even require movement. So what remains is the transfer of someone into exploitation, but not necessarily physical transfer. So I couldn't understand why it was happening, whether it was good or not. That's why I started to look at domestic trafficking as a concept and tried to approach those contradictions. So what are the rationales for introducing this legal instrument into national orders and looking at national citizens who are exploited through the trafficking lens, whether it helped us to address exploitation, forced labor, and other types of unfree labor in national societies, or was it actually substituting labor rights protection for something much more limited? Then also, what policies could be applied there where there is no border control, so no opportunity to catch traffickers there, where the workers are not illegal because they have the right to work, and what protection they can be granted if most measures aimed at protecting trafficking victims are related to the immigration regime and to making people settle in a context that they supposedly do not know anything about. And then on the societal level, how do we justify exploitation of people who are our own citizens? How do we understand their social exclusion? Is there any exclusion in this case? So how it comes that citizens are also trafficked and become modern slaves? And what is to be done with those people? How can they be reintegrated or integrated into a society of which they are already members? So my kind of theoretical framework was based on these considerations, and before starting to look at my case studies, I suspected, and I could confirm it throughout looking at my country cases, that being a victim of domestic human trafficking is something similar to double exclusion, because you cannot abandon your citizenship or your belonging in this society, but at the same time you do not act according to the standards of the society, you do not perform at the level of an autonomous free individual. So since you have already lost your freedom of movement and choice of occupation, right, who are you then, right? So my idea was that victims of domestic trafficking in a way stop belonging in this society. Or maybe they are those who are already on the margins of a society, and that's why they are victims of trafficking. And I also came to this theoretical and then more confirmed conclusion that human trafficking victims, when they are citizens and benefit from protection usually granted to human trafficking victims, that they do not receive more rights than foreign victims, but rather are judged by the discretionary standard that we apply to foreigners, and that it can be actually dangerous for the welfare state and the way that we see the national cohesion. Then it is not necessarily the case, but that's why we need to come to the national context. So my research questions were like these main two. Why do national anti-trafficking regimes increasingly include exploitation of citizens, and what does the trafficking victim status stand for when applied to citizens of a country in which they have been exploited? And I looked at it by comparative case studies, and I looked at my 3 countries, Spain, Ukraine, and the UK, within the international and European anti-trafficking legal and policy frameworks. So these frameworks provided the basis for comparability. The Council of Europe Convention and anti-trafficking monitoring tools that Council of Europe has are the easiest common ground, because all the 3 countries are bound by the same obligations and duties towards trafficking victim. The OCC has also been very active in identifying and helping the countries identify trafficking victims and counter human trafficking. And then the EU is another point of reference, because I have a country that has left the EU, a country that wants to join it, and another country that is a member. So the EU anti-trafficking regime applies to all of them, but to a different extent. And then also, since one of my countries has mainly been seen as a country of origin, it is Ukraine, another is a country that sees itself as a country of destination for human trafficking victims, which is Spain. And then there is the UK, which has both victims who are foreigners and national victims. I have had this diversity in sample, and I hope that it has allowed me to see many different aspects of this national application of the anti-trafficking regime, while still remaining within the broad comparability limits. And I have done it via the law and policies analysis of available case law on human trafficking within the domestic systems and international courts in some cases. also by analyzing academic discourses on human trafficking and the context. So I wish I could do field work, but I wouldn't be able to do so if I wanted to remain within the comparability standards, because I wouldn't be able to reproduce it in all of my 3 case countries. So when I approached the way that human trafficking is defined in the case study countries, I could see similarities as well as the differences. So in Spain and in Ukraine, human trafficking is seen as actual trade in persons. So the emphasis is not on movement, but rather on the transfer of control over a person, which brings us back to the slavery narratives. Then in the United Kingdom, there is the idea of human trafficking, which needs movement, but also modern slavery, which is even more explicit. Then the idea that slavery is imported, and this whole narrative on what is slavery was also interesting there, because for Spain, approaching human trafficking as from the international, transatlantic slavery lens, quite contradictorily, it allowed Spain to ignore its own colonial history, the history of slavery within the Spanish Empire, which ended later than in the British Empire, and also forced labor that went on in former Spanish colonies, and also the fact that most human trafficking victims in Spain, like a lot of them, come from South American countries. And this is something that Spanish policies usually ignore when they adopt the international anti-trafficking discourse. In the case of Ukraine, looking at human trafficking from the international perspective also ignores the history of serfdom that was in place in the country in the 19th century. So when we think of human trafficking as something related to transatlantic slavery, in which Ukraine could not participate, what is forgotten is the history of domestic unfree labor, which was almost identical to slavery. And also the history of forced labor within the 20th century in the Second World War context and during the all-Soviet period, and as well as the practices of unfree labor and other human rights violations that are ongoing now in the zones of the country which are occupied by the Russian Federation. So in the UK case, the most interesting thing is how the UK has managed to take pride in abolishing slavery in the 19th century without taking the responsibility for having perpetuated the slavery in the first place. So all of these are instrumental in enforcing anti-trafficking actions through discourses and in media, and in shaping the way that trafficking is looked at and that human trafficking victims are perceived. Then also exploitation, insofar as it remains seen as an outsider problem, as something that is brought into or outside of the country, remains unaddressed. So in Spain, exploitation is seen as trafficked in. In the UK, the idea is that those people who are trafficked, even if they are locals, may be actually exploited by foreign criminals. And in Ukraine, the idea has been that all the trafficking victims are trafficked out of the country. So in this context, the recognition of domestic trafficking may be problematic. And that's what I could see in Spain, where there is no domestic trafficking, apparently doesn't happen. So the idea that is crucial to the Spanish judicial and academic understandings of human trafficking, something I have seen in case law, is that of uprooting, which is desarraigo in Spanish, which implies that victims are always uprooted from their natural surroundings and brought into Spain to be exploited. And this remains the case even though legally you do not need to cross the borders in Spain to be recognized as a trafficking victim. And since the status of a trafficking victim in Spain is determined by the police, it usually relates to receiving the residence permit and getting access to basic social services, which also means that victims who are nationals will be overlooked. And also the fact that anti-trafficking policies were applied in Spain and approached as something that guarantees the belonging of Spain in the European Union as a sign of its developed Europeanness. So Spain as a country where foreigners are exploited it has both undone the long, well-known history of Spanish labor immigration and exploitation in Western Europe in the 20th century, as well as the fact that not all Spanish citizens have the same standards of life, and that there is inequality in the country which may give grounds for exploitation that might amount to forced labor or human trafficking. And while I was searching for domestic trafficking cases in Spanish, the case database, I found one that was named very interesting by the Spanish government in reports to anti-trafficking bodies. And in this case, victims were 4 Spanish nationals who were either homeless or were suffering from different levels of physical or mental impairment, or both. So they were people
Sorry,
who...
if I can interrupt, that's about 30 minutes. So if you can maybe wrap up in the next 5 minutes, please.
Yeah, I'll try.
Thank you.
Yes, thank you very much. So in the case of Spain, those 4 nationals who were exploited and were recognized as Spanish national trafficking victims and victims of forced labor were those who were very much marginalized from the beginning and were outlooked by the social services, by the police, by everyone who came in contact with them before eventually they were identified as victims of trafficking. And yet the idea remains that there are no Spanish victims in Spain. Then in Ukraine, it's the other way around, because the assumption is that all Ukrainians are vulnerable to trafficking, and since anyone can be trafficked, then it is not possible to externalize the threats the same way. It is not possible to discriminate the victims, because presumably all Ukrainians can become victims of trafficking, and that has been that idea has become stronger in the last years, since the International Organization of Migration assessed half of Ukrainians as vulnerable to exploitation or likely to accept risky work offers. And so it means a bit of a different dynamic, which still does not mean that anti-trafficking helps to address exploitation, but which at least helps to prevent discrimination of people who are seen as victims of modern slavery or unfree labor. At least it should work that way, looking on the policies. And the status of a victim of trafficking in Ukraine is granted by the Ministry of Social Policy, which means it is not connected to the identification by the police and to the criminal justice process. And the idea for this mechanism is to restore the violated rights. And over the past 2 years, many persons who have received this status were identified as victims of trafficking in the armed conflict, and that can mean virtually anything. So it can be victims of sexual violence in the conflict context. It can be children who were deported to Russia, or anyone who was caught there and for whom now this mechanism is used to help them with rehabilitation and restoration of rights, which is an interesting use of the anti-trafficking systems. And the question is also, what do we mean as labor slavery, and whether it's actually slavery, or for some people who are homeless or internally displaced or do not have other options to find a living at the time, whether it may be a way out. And I just wanted to point out this kind of contrast with the announcement that I noticed in my city in December last year, that obviously offered something that would lead to labor exploitation. And then an announcement on the website of the prosecutor of my region, like 2 weeks later, that was talking about 50% found to be in labor slavery. Obviously these do not have to be connected directly, but the question is how we see it, right? And what is to be done when so many people are vulnerable to exploitation just because they do not have better options. Then the United Kingdom is the case which is a bit different, because most victims are now UK citizens, and yet it is apparently not because of the lack of labor rights protection and the erosion of the welfare state in Britain, but rather to the fact that all of them are somehow incidentally vulnerable, either to being old people who are exploited by criminal gangs, or because they are children and are sexually exploited by someone of not UK origin, or because they are homeless and are exploited by traveler gangs and forced labor. Now, there are so many signs of exploitation across the British society, which has to link to the social policies in this country and which are nevertheless externalized and securitized. And I think it is something about securitization of social exclusion and rebranding things that we would previously not name trafficking or exploitation or slavery, right? Renaming that as modern slavery in order to prevent addressing those issues as they should be addressed. And that goes hand in hand with the progressively restrictive policies on who can be assessed as victim of modern slavery. Because the idea is that the modern slavery system is abused by illegal migrants. So this is contradictory, but it also makes sense if we try to analyze the whole anti-immigration policies and the way that these policies have been developing in the recent years. So this has been my case study, and I'm now at the stage of finalizing all of that and trying to come to, to revise my theoretical framework and to come to the definitive conclusions. But I hope I have given you, an overlook of what I'm doing and that it has been interesting and understandable enough. So I will be very glad to hear your comments, and I thank you very much for attention and for listening to all of this.
Thank you very much indeed. And that's flying away as well, the conclusions. And that was exactly the 35 minutes. So well done with your timing too. If I may now pass the floor to our discussant, please, to Dr. Tom Frost. The floor is yours for about 5 minutes, please.
Thank you very much. You can hear me okay?
Yes, thank
Lovely.
you.
Thank you. Thank you so much for the presentation. I just want to say before I start commenting, I'm not expecting, please don't feel compelled to respond in detail to any of these. These are just thoughts that has come into mind. I mean, one thing I had written down, which you reached or got to, was the Illegal Migration Act in terms of the United Kingdom. But perhaps connected to that in terms of thematics is the case of Shamima Begum, which was decided, the Court of Appeal judgment, I think was last week, effectively talking about the relationship between the trafficking risk and also national security. So I'm just wondering if you're working that into your work or how you would consider that. And I think connected to that is the fact that given the United Kingdom is the one country out of the three you're looking at without a codified constitution, our rights to citizenship and belonging are entirely given by Parliament. We don't have a codified document to go there. So certainly there's been a lot of criticisms, people like Nadine El-Anani and Koja Karam, who've made criticisms that citizenship in the UK is very much racialized. Simply because if Shamima Begum had two parents that were British, she would still be British. Sorry, not who were born in Britain, I should say. The other point, I think I noticed a reference to White 2019. I'm wondering if that's Jessica White. It is. Lovely. Good. It's a good guess on my part. It's just a passing comment. She's written an awful lot on human rights, and we're talking about the Westphalian system and state centrism. She wrote a piece about 10 years ago on the Universal Declaration of Human Rights, where everyone was having a debate about Robinson Crusoe. All the kind of delegates about whether human rights should or needed to be attached to the nation state, or whether they could be this kind of free-form citizen of the world. And as we all know, the statists won out. Specifically, the Soviet Union were lobbying hard to say that human rights come through citizenship. And maybe that's a connected point to Begum as well, in terms of we have rights because we belong somewhere, and we have rights because we have certain papers. And if we suddenly don't have those papers, then those rights become a lot less tangible than we think they are. Definitions of slavery. I was just wondering where you were, and forgive me if I missed this, I was just wondering what kind of your definition would be. I'm also thinking of Orlando Patterson's work, back in the 80s when he wrote Slavery and Social Death, when he viewed it kind of almost an anthropological definition of slavery as social death. So I'm wondering, I know lawyers, we like definitions, but I am wondering whether that may be something that could be of use, because the victim of human trafficking, even the exploited worker, could be seen as much more socially dead rather than legally so. And then just, this may be a very broad point, but we talk about human rights, we talk about citizenship. Ultimately, our legal definitions are based on recognition, a form of recognition recognised by another person. And just philosophically, I mean, generally that's traced back to Hegel in the phenomenology of spirit. And maybe this is a small irony, but that is based on his master-slave dialectic. So we have this kind of tradition, this philosophical tradition in the West, based on an unequal recognition. Hegel wasn't being literal, but certainly Marx took him to be, and he turned the master slave into the bourgeoisie and the proletariat. But it's a broader point where our political philosophies are based on recognition, and so that gives a lot of power to the person or the organization or the country who has the power to recognize. I'm not sure we can solve that on a Wednesday afternoon, but I may just leave that point there. I think that's all my points. Thank you very much.
Thank you very much indeed. Can I also then, just in the interest of time, move on to our peer discussant? So Yelyzaveta, you can think about responses, and if I can now open the floor to Roua Al Taweel, who's our peer discussant, for again about 5 minutes, please. If you've got any comments or questions for Yelyzaveta, thank you.
Yelyzaveta, I've gained a wealth of knowledge from your research. Thank you a lot for a very informative and excellent presentation. I'm completely oblivious about the field of human trafficking. This topic seems incredibly important and multifaceted, as demonstrated by your insightful slide outlining the international legal anti-trafficking framework. Your clear and comprehensive overview was amazing. I appreciate also the depth of your research exploring, like the exploration of the racial, gendered, and colonial/imperialist roots and dimensions of human trafficking practice, and its related legal frameworks, the evolving discourse, the silences, the contradictions. The comparative analysis of anti-trafficking national regimes as well in Spain, Ukraine, and the UK is another very interesting aspect to your research. The different policies, especially considering these countries have different policies, economic and socio-cultural situations. I would be curious and wonder if you can speak more about the methodological approach, the temporality or timeline you're looking at, what sources are you viewing. From what I gathered, but maybe you can speak more, you're fluent in all 3 languages, which is great. Could you speak about, for example, access to the sources and in terms of logistics or languages? I'm also curious about your stances in relation to decoloniality in general, whether this is relevant to your research or not, or maybe part of your theoretical framework. Yeah, that's all I have. Like overall, I really enjoyed the presentation, and you demonstrated very well the complexities surrounding human trafficking and the state's obligations towards victims. So I really look forward to seeing how you progress in your research. Good luck.
Thank you very much indeed, Roua. So Yelyzaveta, would you like to respond to the comments that we have?
Yes, thank you very much, Tom and Roua, for the comments. I'll start from the beginning. So speaking of Shamima Begum, I was going to review the criminal tribunal decision because I previously wrote about that. So it is part of my section on the UK, my chapter, the way in which women and girls who traveled to Syria or other spaces where the Islamic State was active, and who were branded as non-citizens instead of trafficking victims, despite the thing happening to them being exactly or pretty similar to what is happening within the UK to other girls who are groomed into sexual exploitation. So it is definitely something that I am looking at, and that also shows us how belonging is racialized, gendered, and also how it is arbitrary, and how this decision whether someone is a victim or a criminal, is not fair at all, but also how it tells us about the dynamic of the state about which we are talking. And the Legal Migration Act is, just part of all this kind of pattern, which is fascinating, but also horrific to watch. And then, the fact that the UK does not have a constitution and that it is a different legal system to what I'm used to has been kind of challenged. But I will also look at what you have suggested, at how citizenship plays out, because I have already understood there are different layers of citizenship here, and something that to me is also quite interesting and unusual. Then thank you for also the comment on Jessica White's work. I should further look into that. And obviously, the fact that human rights are attached to our citizenship, I think it was already said by Hannah Arendt, and there is much to talk about there. And it's something that I'm trying also to elicit through my work. So whether we are, by being labeled as victims of human trafficking, whether we receive more rights, or is this act of labeling us and identifying us as victims of human trafficking actually moving us to the non-citizen category? And that will come to, to your point also on recognition and all these dialectics. I've been looking at Marx as well, but I'm not a Marxist. I don't believe in sticking to any school of thought generally. So it is all there in my theory, but thank you very much also for pointing out this. It's really very relevant. And then Patterson was my starting point somewhere when I was doing the master and started to look at this connection of human trafficking with political theory. So it is also there. So as for my methodology, so thank you for asking that. So it is, as I have said, kind of it's a broad social legal approach, because I don't only look at the laws, but also try to look at discourses and the social situation. But then the basis for me to look at every country is to obviously look through criminal legislation and other legal frameworks on human trafficking, the way that the international anti-trafficking treaties have been applied in this country, then also anything else from the legal standpoint that attaches to it, and also to look if it is available at public policies on human trafficking, and the time frame in this case is from the beginning of the anti-trafficking policies, because fortunately it's only about 20-25 years depending on the country. In Ukraine, the human trafficking offense was introduced in 1998. And the first anti-trafficking policies date back to that point. In Spain, it is 2010. And in the UK, also the first anti-trafficking provisions are 2002, but then the most interesting part is in the 2010s. So it is a time that I can look at and also compare, because it was happening at the same time, more or less, in all the countries. So there is this interesting dynamic of the international anti-trafficking dynamics, the national dynamics, how it correlates, what impacts what. Because in the case of Ukraine, our definition is previous to the Palermo Protocol, so it is quite specific. But then in the case of Spain, all the anti-trafficking things were adopted because the European Union was pressing for it. So it's really interesting to look at. Then as for other sources, I was also looking at case law, and it also depends on the country. So in Ukraine and in Spain, I can access online the database of domestic courts of the first instance. Then in Spain, I can access everything, but they have very few cases, and I may have missed something, but I don't think so. So I found like 5 cases on domestic trafficking since 2010, which is not much. in Ukraine, the archives are partially closed in what relates to war crimes investigations that may have trafficking, and I'm very interested in looking at that, but that is closed. And then also I accessed it like in 2022, somewhere in the summer, and I could access a lot of cases from all the country. I went back to the archive, it's online, last year, and the territories which are partially or completely occupied by Russia, they know the cases have disappeared from there. I guess they closed it for the safety reasons. So I know there are issues, but there is a lot of material on that can allow me to look at the patterns of how domestic courts adjudicate on human trafficking cases. In the UK, since I cannot access first instance courts and court judgments, and I realized it too late to apply for access and to decide which crown courts I could go to, so I have been limited to the tribunals and the second instance judgment. So it's only the cases that were appealed that I could look at. But luckily, there is some literature. There have been previous researchers who previously looked into trafficking for labor exploitation, for example. There is an excellent book that looks at labor exploitation and trafficking cases from 2010 to 2017 in England and Wales. So that was helpful to look at whether what we have seen in the appeal courts corresponds to what happens on the on the ground. So it's about that. And yes, I'm fluent in all three languages I'm looking at. I'm fluent in Spanish. So yeah, and I for the case of Spain, I was able to travel for a research stay and go to the library, there and access printed sources. In Ukraine, also went to the library, but on my own behalf, because no one would be giving me a research stay there, or the university would not approve of any field work. That's why I also had to abandon any idea of conducting interviews, because I wouldn't be able to replicate that. Yeah, so but overall there is a wealth of things to look at. And then I think there was also a question on the pandemic in the chat.
Yeah. That's what I was going to ask, if you could just quickly look at, yes, okay, from Bernardo Cavallo.
Yeah, I do not focus on it specifically because there was a short-term impact, and I looked at it in the Spanish case. In my master dissertation, it was comparing trafficking discourses in Spain and Italy. It was in 2021, so I could see some very interesting patterns of public representations of trafficking. So for example, it was the case that the traffickers were recently, what was that word? So out of a sudden, the trafficked people and the traffickers were also not only criminals and victims, but also the those who were bringing the disease into the country. So that was the case in Italy. In Spain, trafficking moved from, trafficking for prostitution moved into flats, which were even more difficult to identify. And also there was an idea at some point that those people who were still going to purchase sex services during the confinement period were infringing not only the moral standards of not purchasing sexual services, but also not compliant with public health requirements. So we're doubly responsible for that. But then in the longer term, obviously, the pandemic has exacerbated all the vulnerabilities and all the dynamics that were already there. In Ukraine, since 2020, most victims are domestic. Previously, there was more of a balance between those people who were identified as victims after coming from being exploited abroad and victims exploited nationally. But then as the borders closed, it changed. So yeah, I don't look at it specifically, but it is there because the years that I have most information and analysis on are obviously the most recent ones. So
thank you very much indeed. So that brings us almost, with about a minute or two left, to the end of our session. So please may I first of all thank very much Yelyzaveta, Tom and Roua for their work on the session today. So thank you very much to the three of you. Very good luck to Yelyzaveta with your PhD. It's very interesting and very, very timely. So very good luck moving forward with your analysis and conclusions. Also, if I may point out that our next session, next Wednesday, for those of you who are not aware of it, we have ones every week. So you're more than welcome to join us next week when we have Palin Lee, who's a PhD candidate at the School of History in the University of Leicester, will be talking about the research with a seminar entitled Jianghu, the Social Organisations Between China and Japan 1930 to 1945. So another very interesting session will be there next week. So thank you very much indeed. And it's also posted in the chat the 2 sessions that are organised by the Global South Network on the 6th of March. One, Constitutions in Uncertain Times, a South Asian Perspective, and the other, Cutting Edges of Decolonial. And you've got the meeting chat has also got the links to them if you want to join us on the 6th of March. So thank you very much indeed, Yelyzaveta. Fantastic presentation, very interesting, and very good luck for the future. Thank you everyone for attending, and I'll be 1 minute over if I don't be quiet very soon, so I shall let everybody leave. Thank you very much, and I look forward to our meeting next week. Goodbye, and thank you, Yelyzaveta.